we're ready to proceed to our next case. So the second case on the calendar this morning is number 2889 by Tovis versus City of Greenville. We've confirmed the parties are ready to proceed, so we'll hear from the appellant.
May it please the court, I am Dan Gibson. I represent plaintiff appellant Mary Sue Vaitovas. The issue in this case is whether Session Law 2016-64 is an unconstitutional local act that relates to health. All the parties here agree that it is a local act. All the parties also agree that that act was necessary for the creation of Greenville's red light camera program. The remaining question really is whether or not that red light camera program unconstitutionally relates to health. We believe that it does. I'm not going to rehash our briefs, but there are three principles to keep in mind from those briefs. The first is that a health-enabling act relates to health. The second is that health funding relates to health. And the third is that in certain circumstances, safety relates to health. There are three reasons today why you should reverse the trial court. The first reason is the difference between Session Law 2016-64 and other laws invoking the general police powers. The second reason is the difference between a red light camera enforcement program and a general law making running red lights criminal. And the third reason is the original meaning of relating to health, sanitation, and abatement of nuisances. I'd like to begin with the first reason because, in candor, Your Honors, that is the reason that would give me the most pause were I in your shoes. If you were to rule in our favor today, what would that mean for other laws invoking the general police power? If a statute says we're doing this to promote health, safety, welfare, morality, so on and so forth, the general welfare, does that mean that all of those laws are unconstitutional local acts relating to health? And the answer is no. The answer is no because of the standard that the city of Asheville lays out. That standard is not a rational basis standard. That standard looks at the actual justifications of the specific legislation that the court is reviewing. And it examines whether the stated purposes of that legislation and the practical effects of that legislation have a material connection to issues involving health. Our argument on this point is simple. The necessary effects of a program are by definition materially connected to that program. Everyone here says Session Law 2016-64 was necessary for the red light camera program. That program was the effect of this legislation, and that program had two effects. We agree, it saved Greenville money. It produces revenue, but it also had a health effect, and the record evidence is clear that that was one of their stated purposes and one of their practical effects.
So one argument I think we'll hear is that you could have provisions in a law that are absolutely necessary to carry out some other provision, but still be tangential or incidental to that underlying purpose. So, and those were the words that our Supreme Court used. So how is the actual health aspect of the challenge statute, not just incidental or tangential, and what's really the heart of it is, you know, finding a way financially to be able to make it work for this particular local community?
Your Honor, I think that depends on the specifics of the legislation, and that sort of line drawing is the line drawing that I think the City of Asheville test requires. When you look at material connection, to me that sounds a lot like the sort of line drawing that courts do when they're examining proximate cause. Is this, is the effect of this legislation really materially connected to that legislation, or is there some other cause that comes in and actually causes that effect? I think the best evidence here that the health effects are materially connected is the health effects are no more connected than the financial effects. This legislation says, sure, Greenville, you can charge more money when people run a red light. Well, if nobody ran a red light, those effects wouldn't accrue to Greenville. The effect of the increase in penalties is only experienced through the red light camera program. The red light camera program creates both the funding for Greenville and also the health effect. So if the health effect is tangential and incidental, then the finance effect is tangential and incidental as well.
Well, what about the argument that if you strip this statute away the City of Greenville could still have a red light traffic camera program.
That is certainly correct. We agree with that, Your Honor. I think the reason why that doesn't defeat our argument is when you look at cases like Lamb or James Walker, that's the principle that health funding still relates to health. So if the General Assembly were to say Greenville can levy a new tax for a hospital, which is exactly what happened in James Walker, or if the General Assembly were to say they can't spend any money on this hospital, which is similar to what happened in Lamb, that would still relate to health. The key there is that it doesn't have to be a direct relation. It doesn't have to be exclusive or predominant, in the words of City of Asheville. It just has to materially connect. And I think that gets to why we're challenging this specific regulation or this specific law and not the general law allowing Greenville to have red light camera programs. Sure, Greenville could have a red light camera program, but until this law was passed, it was, in their own words, not financially feasible for them to do it. So this law was necessary for them to be able to afford to have this red light camera program, and all of the effects of the red light camera program flow from this legislation. And those effects are important because, as I said earlier, there's a difference between a red light camera and a law making the enforcement or making running a red light a criminal infraction. When you just say it's criminal to run a red light, there still has to be some sort of enforcement mechanism. This legislation changes the enforcement mechanism, which City of Asheville held relates to health. Changing who enforces health statutes relates to health per City of Asheville. And what that change in the enforcement mechanism does is instead of having a police officer sitting there watching everyone go through the red light, imagine you have at these same intersections police officers there 24/7 watching the red light camera, or watching the intersections to see if someone runs a red light. Number one, that's going to cost the City of Greenville a lot of money. So that's one of the effects of the red light camera program, is it does save Greenville a lot of money. The other thing is, even if there's a police officer there, he's not paying attention necessarily all the time. He's got to sleep, he's got to eat, so on and so forth. He blinks. Red light cameras don't blink. Red light cameras don't eat. Red light cameras don't sleep. They monitor the intersection continuously, and they put everyone going through that intersection on notice that this is a monitored intersection, and if you run this red light, you are going to get a notice of violation for running the red light. And that is a second effect of this legislation and this program. And that's where the health effect comes in, because people behave differently when they know they're being monitored. And that's exactly the evidence that Greenville presented to the voters at its city council meetings. That's exactly the evidence that was presented on the floor of the General Assembly. That because these monitor intersections continuously, yes, they raise revenue, but they also save lives. They prevent injuries, because people are less likely to run that red light if they know someone is watching them and they can't get away with it. That's their argument. They didn't have to say that to the public. They could have said this is just about raising money. But they said this is about saving lives and preventing injuries. And they got darn close to saying it in the case immediately preceding this one. I think that is their legitimate interest here, Your Honor. I think maybe that's a compelling state interest. If they had argued their legitimate interest was just raising revenue, I think Farrington would look very, very different. So they've admitted that one of their purposes here is to promote health. Thirdly, ruling in our favor is consistent with the original intended meaning of relating to sanitation, health, and the abatement of nuisances. What you've got here is you've got three words in a sequence. You've got the narrowest word first, and you've got the broadest word last. Sanitation is a fairly narrow category. Health is a broader category. Abatement of nuisances is an even broader category. When you look at abatement of nuisances, that can cover things that have no relation to health. In our brief, we cite a case saying that a freight train station can be a nuisance. I think the defendants somewhat can conflate sanitation and health. It's difficult on their definition of health, I think, to see a program that would relate to health that would not also relate to sanitation. Unsanitary condition is going to be a condition that is likely to cause some sort of illness and disease. So if you were to think about something that relates to all three, if I have raw sewage in my backyard and the city wants to do something about that, that's going to be a nuisance, it's going to be a health issue, and it's going to be a sanitation issue. But you can split those things up and you could say, well, unclean water relates to sanitation, also relates to health, doesn't relate to nuisances, it's still unconstitutional. So it doesn't have to relate to all three. What's, I think, particularly interesting is when you look at the cases that had been decided by the North Carolina Supreme Court immediately before this constitutional amendment in 1916, adding this provision on local acts relating to health, sanitation, or abatement of nuisances. When you look at those cases defining what a nuisance is, and we submitted this in a memorandum of additional authority to the court, their definition of abatement of nuisances is very, very broad. One case, Vickers, defines nuisances as offenses against the public morals, the unlawful obstruction or use of the public highways, acts endangering the health or safety of human beings, the overhanging of another's land, for the reason that proof other than the fact of their existence is not necessary to establish the nuisance. That's a public nuisance per se. And that case had been decided before the Constitution was amended. Secondly, and perhaps most interestingly, the City of Durham case that we cite says that such enactments are regarded as police regulations, enactments preventing nuisances, established for the prevention of pauperism and crime, for the abatement of nuisances, and the promotion of public health and safety. So nuisances ties health and safety together. It says something that's a nuisance could very easily be harmful to the public health or the public safety. Now, we're not arguing that this red light camera program abates nuisances. We are arguing that it relates to health. And our argument is that when you look at relation to health in that 19th or 20th century context, don't bring in all of the modern administrative state. Don't bring in all of the OSHA regulations and the strong sort of dichotomy we have between health and safety today. Look at the laws that they were looking at. Look at the cases that they were looking at, and look at the words that they put there. They put sanitation and health together. If that was where the Constitution ended, I think my friends on the other side would have an excellent argument. But then you see abatement of nuisances. Abatement of nuisances expands the meaning of this section to show that health is not just prevention of communicable diseases. Safety relates to health. It's not the same thing. But everyone knows when you pass a public safety ordinance, when you say, for example, a building and fire code, as was the case in City of Newbern, the prevention there is the risk of fires and explosions. Those are things that harm people's lives. Or if we were looking at whether or not this building is structurally sound, why do we care whether or not this building is structurally sound? We don't care whether or not this building is structurally sound because we want it to look pretty. We care because if it's not structurally sound, if it's not safe, the roof might collapse on our head, and we might die, or we might go to hospital. So not in every case safety is going to relate to health, but in many cases safety will relate to health, and you have to look at the stated purpose and the practical intent there. I don't know if I should reserve if I'm allowed to reserve the rest of my time for rebuttal. Unless your honors have any questions, I'm out of argument at this point, and I don't want to just stand up here and ramble to you.
Well, we'll let you reserve your time, but let me ask you one question then.
Sure. I'm happy to answer whatever questions.
Do we have, is there any case law or any guidance we have on how to figure out if in the early 20th century a traffic law would have been considered a health law? Because that seems to be the key question here is traffic safety part of health? Because I think the framers of this provision would have viewed a red light, they of course couldn't have imagined the red light traffic camera laws the way they operate now, but that sort of thing as being a traffic safety, not a health law. But it may be that word's meaning at the time included that, and we would need to figure that out. How do we do that?
I think those cases on nuisances are really the best way of indicating what they would have thought of this issue. But I think that also gets to the the difference between the technology that we're looking at today and the technology that was in place in the 20th century. The key here is not that this law criminalizes running red lights. The key here is the automation and the technology behind this. This is, essentially robotic, automated enforcement of criminal laws. It's not that the underlying criminal law necessarily relates to health. It's that when you put this enforcement mechanism in place, it creates this health effect. And I think it is really hard to sort of jump in a time machine and go back to the turn of the 20th century and say, if the people who wrote this amendment were able to envision a machine that would, with 100% efficiency, enforce a criminal law and thereby deter people from violating the law, would they have thought of that as relating to health? I think really the only way to reasonably answer that question is to look at City of Asheville and say the way we determine whether or not there's a relation to health is we look at what they said to the public, we look at the effects that this legislation will have. And let's not forget that this was a summary judgment, cross motions for summary judgment. The only evidence in the record showed that one of the stated purposes was its health effect, and one of the practical effects was its health effect. Now, we argue that the health effect would actually be detrimental to health, but the evidence in this case was from the defendants that there would be a beneficial health effect to this legislation. I haven't found many cases on point at the time that this amendment was enacted, clearly defining health or clearly defining safety. I think that's a dichotomy that arose because of increasing regulation, both at a state level and at the national level, and an increasing recognition that there is a dichotomy between these two things. But those cases on nuisances aren't just about nuisances. They talk about health and safety together. Acts endangering the health or safety of human beings are nuisances. And police regulations preventing alcohol are established for the prevention of pauperism and crime, the abatement of nuisances, and the promotion of public health and safety. If you look at the original meaning of safety in our Constitution, there's one article that used the word safety before this 1916 enactment, and that talks about political safety and happiness of the people. It's sort of a Lockean right to revolution, that we can dissolve our government when it's harmful to our political safety and happiness. Well, political safety and happiness, to me, sounds reminiscent of the Declaration of Independence line about life, liberty, and the pursuit of happiness, which of course also relates to John Locke's life, liberty, and property. And we would say that this law is about preventing injuries and saving lives. And if you're reading safety to include preventing lives in that context, why not read it in this context? There are some subsequent enactments that the legislative defendants rely on in Article 5. I would just point out to your honors that the amendments to Article 5 that they point out were not made until 1971, so they can't possibly inform our understanding of a 1916 amendment. It is a very good question what the original meaning was here, and I think the best way to do that is to look at the case law. Now, my friends on the other side are going to say, well, there were these other local acts that we found that haven't been challenged or that we can't find a case overturning. That doesn't prove that they're constitutional. Just because someone doesn't challenge something doesn't make it constitutional. And we've also presented to your honors several Superior Court cases striking down local acts that if you look at the annotations to our general statutes, those cases are not found in the annotations. So it's entirely possible there were Superior Court decisions that we're not aware of that overturned any of these local acts that have been cited by my friends on the other side. It is very hard to imply something or infer something rather from pure precedential silence here, which is why we've tried to find cases where the precedent does speak. And those nuisances cases are, I think, the clearest case where the precedent does speak. And I don't think they have a good way of explaining why nuisances isn't included in this constitutional provision. If it were just health and sanitation, I would possibly agree with them. But it doesn't stop there. It goes on to say nuisances, and that necessarily broadens the understanding of health that this court should have. And that relation to health question implicates safety and it implicates safety in part because of the defendant's own statements here, because of the record evidence here. And when they argue, they have to try to avoid that record evidence because the record evidence shows what the stated purpose was, and it shows the practical effect. Sure, there was a financial effect, but there was also a health effect. And when there's a health effect in legislation, that legislation necessarily relates to health. And that's why you should reverse the trial court here. And with that, I'll reserve my time for rebuttal unless your honors have any additional questions.
I have on one more. I guess my question is, sometimes when the silence is so loud, isn't it more appropriate for the folks in the legislature to take up fixing something than the courts? Because that silence creates such a gap for us to have to make up. What do you say on the issue of the lack of the case law that doesn't give us the guidance that we need on this issue? That this is not an issue that's more ripe for the folks in the legislature to take up to fix it versus the court?
Well, one of the reasons why there is such silence in the case law here is because the legislature took exactly the action that you're suggesting. We can point to local laws on traffic safety up through, I think about the 1930s is the latest one they've cited. Don't quote me on that, you'd have to look at their memorandum of law. But there aren't local laws relating to traffic safety here these days because we have Chapter 20. The legislature codified traffic safety laws, put them all together and said, this is going to be a uniform statewide system of traffic laws. That's what the legislature has done. And here they've carved out an exception. They've said, we have this unique enforcement mechanism only for these localities. There's no difference between running a red light in Greenville or Raleigh or New Bern or Manio or Rocky Mount, wherever you want to go. Traffic safety is traffic safety. The laws of the road are the laws of the road wherever you go. There's no reason to carve out this exception from the general law that the General Assembly has already enacted for traffic safety. If red light cameras are great, then let's have them for the entire state. Let's not carve out an exception for whichever municipality comes hat in hand to the legislature and says, hey, please give me an exception to this general law that you've already made. So I don't think the silence here is very loud. I think there's a brief silence before we get Chapter 20 together on the books. But then once we get Chapter 20 on the books, everything runs through Chapter 20. If there's nothing else, I'll reserve my time for rebuttal.
All right, thank you, counsel. We'll hear from the appellees.
May it please the court. My name is Elizabeth Troutman, and I, along with my partner Bob King, represent both the city and the Board of Education in this matter. I believe the other folks have been introduced, but I will be reserving half my time for counsel for the legislative defendants, Phil Berger and Tim Moore, Mr. Ryan Park. Unlike the Farrington case, the question before you in the Vaitovas case is a very simple, narrow issue. Is a local act authorizing Greenville to enter into contracts for red light cameras related to health? And the answer is a simple answer. No, it's not. The General Assembly is afforded a presumption of constitutionality. When they enacted Session Law 2016-64, nobody thought this is somehow going to be considered to be related to health, right? Because it's about how to pay for cameras. It's not about health. Nonetheless, I think, to address the appellant's arguments in this case.
Yeah, I mean,
Go ahead.
if I understand your argument for the friend for the appellant, it's that if you look at the two tests, which are what's the stated purpose and what's the practical effect, and they've said you can see in the stated purpose some discussion about the benefits of red light traffic cameras that we think proves health, and then more importantly, the practical effect is the City of Greenville can't have red light traffic cameras without this law, and we can prove that, and that shows that this has to relate to health if we've shown that red light traffic cameras relate to health. So what's your response, I think in particular, that second argument, that by showing Greenville can't do it without this law, that makes this law relate to health?
Sure, Your Honor. I think you were correct earlier when you said it all comes down to materiality. It has to be a material connection to health. So if a butterfly flaps its wings in Australia and then it rains in Mexico after a series of events, yes, we could link cause and effect. But that's not what Session Law 2016-64 does. All it does is authorize these contracts. But to get to the point about the evidence, the stated purpose is in the law itself. And the law itself says this is to change existing authority to implement red light cameras. It says that right there. And then in the legislative history, when you look to the hearings, Representative Murphy, it's now Congressman Murphy, stood up and said, this is about being able to contract. That's the stated purpose. There really isn't a dispute about that. We've also submitted affidavits from Representative Murphy and Senator Davis, folks on different sides of the political aisle who sponsored this bill, and they say the stated purpose was to allow Greenville to enter into these contracts. It wasn't health. But the practical effects, Your Honor, the evidence is also demonstrably clear on the side of the city. There are affidavits from the city manager, the finance officer for the Pitt County Board, the superintendent, and probably most importantly, the chief of police, who all talk about the practical effect here. These are the folks, by the way, who are dealing with this practically, is efficiencies for law enforcement and generation of revenue. That's the practical effect. You know, it really boils down to, Chief Holtzman is in the court with us today, him being able to run his department, because it's expensive to have officers sitting by traffic lights when they could be doing other things. So this doesn't change who enforces the traffic laws, right? All it does is create some efficiencies for his department to be able to enforce them. That's the largest practical effect. Yes, almost every law has some kind of impact on human life. But what Justice Irvin said in the city of Asheville is it has to be a material connection. And that actually sort of runs through all of the case law on local acts. If you look at City of Asheville, he talks about the connection cannot be tangential or incidental, right? And in that case, it was about transferring water supply. Water. What water you drink clearly has to do with health and sanitation. But Justin Irvin had a concurrence in the town of Boone, which came out the exact same day. And what he said in that case was, well, I'm looking at the Land Use Commission in Boone, and the things that they regulate don't have a material connection to health. And he pointed out, there are things like transportation, infrastructure. Those things aren't materially related to health. Water supply is. And so he created these two situations that we can compare ourselves to. Is the traffic law more like transportation and infrastructure, or is it more like water? It's more like transportation and infrastructure. And I think you can see that too in the city of New Bern case, which I really want to distinguish for you. So in New Bern, that case was about enforcement of building codes in schools, the community college, and the medical center. And the court went and looked at the building code and talked about ventilation, plumbing, the materials that are used, water. All of those things in a school or a community college, or especially a medical center, are going to have a material impact on public health. What happens if you contract for a red light camera doesn't, right? There's maybe some tangential, eventual connection, but the question for the court is it material?
I guess but for a Chapter 20 statute, you really have nothing to enforce there, right? I mean, this is it's born out of a Chapter 20 violation, traffic violation.
It is a traffic violation and that law is the same across the state of North Carolina. But this is about local law enforcement agencies being able to organize their departments so that they can function efficiently. And that's going to depend on the local conditions. I want to go back to the Town of Boone case because Justice Newby made a point in that opinion that I think runs through these local act cases as well, which is the principle that the constitutional amendments in 1916 did not take away the power of the legislature to organize local government and respond to the needs in local communities. If it had, it would have prohibited all local acts. Instead, it laid out a specific set of categories, right? But here, this is about just funding in local government. And the General Assembly is the body that's best suited to be able to address those issues. You see that in the Armstrong case. You also see that in the Chief versus Town of Chapel Hill case, that principle running through these things. And it goes to the presumption of constitutionality here. Finally, I do want to address this question about how do we understand what the folks in 1916 would think about traffic laws. And, obviously there weren't red light cameras. I don't even think there were traffic lights. But the local act prohibition has several different categories, as you know. There's the health, sanitation, abatement of nuisance one. And then there's actually one for the laying out of roads, bridges, and highways. So if it were unconstitutional for the General Assembly to allow a municipality to contract for certain types of roads and highways, then that would be, contemplated in that provision. So, what I'm trying to say here is that at that time, even though they didn't have red light cameras, there was a distinction between transportation, roads, highways, bridges, and health, sanitation, and the abatement of nuisances. Those were different things. They still are different things.
So do you see a difference between, for example, a law that requires you to wear a helmet on a motorcycle and a law that says don't run a red light in the question of whether it's a health-related law?
I think the helmet might be a closer question than the red light, because it's not, the red lights are also managing the flow of traffic. But what's important here is that the person on the street, the individual, the law of general applicability is the prohibition on running red lights. And so this statute, Session Law 2016-64, didn't change that. You're not supposed to run a red light. You're still not supposed to run a red light. And so, the question about helmet safety, is that safety or health? I'm not quite sure, but it's not really what's at issue in this case.
It's just that you can see how the challenge that we have is understanding because certainly a red light law, like yielding to pedestrians and other traffic safety laws, have at their core avoiding injury to people or harm to people. And figuring out in the early 20th century, was that kind of safety different from using the word health? That seems to be the real core of the question, and it's just one that we don't have a lot of guidance on. Why those three words, in this prohibition on local acts, and what is different? What is about health is, how large is it? Because as you heard your friend for the appellant say, you could read nuisances to take in all of the social welfare, police powers laws. So, it's very hard for us to figure out what they mean. So what guidance do we have?
Yeah, I understand that, but I think that the question for the court is, how do we circumscribe these different prohibited categories? And if it's not squarely within one of those categories, clearly on its face, then we have to presume that the legislature has made its decision that it's not within those categories. And you can see in the hearings when the legislature was looking at 2016-64, they clearly thought this was about contracting and finances and had nothing to do with health. If there are no other questions for me, I'm going to yield my time over to Mr. Parks so that the state can present their case as well.
All right, thank you, counsel.
Good morning, Your Honors, and may it please the Court. I'm Ryan Park from the North Carolina Department of Justice, and I'm pleased to be here representing the state's legislative leaders, Speaker Tim Moore and President Pro Tem Phil Berger, in their official capacities as the state defendants in this case. So for at least three principal reasons, a local law that helps to facilitate the financing of a red light camera program would never have been understood at the framing of this amendment to be a law relating to health. So first, the only case law we have on the original purpose of the amendment is from Nash County, and that case says that the framers of the amendment used the word health to refer to communicable diseases, the alleviation of illness and suffering, and related issues such as medical care. It's true that all safety laws has some downstream connection to these issues, but under Asheville, what we're required to inquire into is whether that connection is material. And for a couple of reasons, I also think the framers would not consider the connection between traffic safety laws and health to be material. And so the first is, what did the actual framers of the amendment, which was the General Assembly, not the North Carolina Supreme Court, it was the General Assembly, that General Assembly that proposed this amendment for ratification of the people, immediately after it was ratified, they began passing local traffic safety laws. And at that time, it was principally related to speeding in particular areas, such as in particular counties, around particular schools. I think we probably don't give our forebears enough credit in terms of the technology available at the time. At that time, I just looked this up, there were around 5 million cars in the United States. Traffic safety rules were a common topic of legislation. And throughout the late the teens and into the 20s and the 30s, all the way through the 60s, as some of the laws that we've submitted to your court show, the General Assembly was routinely enacting traffic safety laws. And so that shows what the framers of the amendment actually thought. And third is, as we learned in 1917, so later in the year that the local law amendment was ratified, our North Carolina Supreme Court said that it was never the intent of that amendment to constrain the General Assembly's authority to facilitate the financing of local projects that might be related to these prohibited subjects. And so in that case, it was a highway, that was Brown. But a couple years later, there was a case, and 2 years later, there were two cases involving bridges, and that is a relating to bridges subsection of the local law amendment. And those cases say that if the General Assembly wants to pass a law to help finance a road or a bridge, then that's perfectly okay, and it does not violate the local law amendment. And so I'd like to speak about, there are some healthcare cases, and I'd like to explain, if I may, why those cases are different. So James Walker and Armstrong, those cases both involved a situation where there was no underlying authority to engage, for the local government in question to engage in the activities. In fact, in James Walker, the Supreme Court said that it was affirmatively unconstitutional. So what the local law there did is it forced, I believe, Wilmington and New Hanover County to fund a hospital. And what the Supreme Court said is that it was unconstitutional for the General Assembly to try to force them to do that because it violated Article 5, Section 4, which prevents the General Assembly from passing laws forcing local governments to go into debt. And so that was not a supplemental financing law the way that the laws in Brown, Mills, and Martin County were. But here, that's what we have. So everyone agrees that there is a general prohibition on running red lights. And in fact, we're in a somewhat strange situation because here there's no challenge to Greenville's red light camera program, only the financing aspect of the program. And that is, on all fours with these early cases, also with McIntyre, which we've discussed in our brief, and with Asheville itself. So we cited in the supplemental memorandum of authorities how the Supreme Court in Asheville, they affirmed or ratified. It wasn't strictly speaking before the court, but they said this court's case, the Court of Appeals' case decision in Asheville 1 was correctly decided because those laws, the Sullivan Acts that issue in Asheville 1, those were all economic in nature.
So the argument, though, as I understand it, is essentially that we should treat this statute like enabling legislation, because without it, you can't get to the underlying red light traffic camera. And so you can't put blinders on and ignore the fact that the enabling legislation must relate to that underlying thing because it's allowing it to happen. So what's your response to that?
Yes, Your Honor. So I think that there's kind of some slippage here in terms of what is actually necessary. So it's true that there's some statements from the Greenville City Council and others who say it's as a practical matter, it's not feasible for us to operate red light cameras because we'd have to operate them at a loss. And I just footnote that the loss is not that great. My understanding is it's less than $100,000 or so to operate this program a year. So a municipality could, using its authority to operate a red light camera program at a loss, say this is worth it for our citizens and we're going to operate it anyway. So it's true as a practical budgetary matter, Greenville was not going to red light violations. It is true that they could hire a bunch of additional officers and monitor these same, I believe it's 5 or 6 intersections, and issue red light tickets to anyone who violates the law. That would just be prohibitively expensive. And so that, in our view, falls under the financing exception that we've discussed in our briefs. And I think that in all of these inquiries, and just to touch on a point or comment or question that Judge Gore made, I think throughout all of our state's cases on this issue, you see a deference to the General Assembly that permeates the entire analysis. So when you look at what is the stated purpose of the law, I actually can't find a case where they even look to legislative history, although we're not going to discount it entirely, but they always look at what the text of the statutes say. So in Asheville, that's the case. They say, what does the text of the Drinking Water Act say? In New Bern, it's this case, it says, what does the text of the building code relevant statute say? It says that the building commission shall promulgate regulations that have a substantial connection to the public health and other topics. And so when the General Assembly says it relates to health, that makes the court's job very easy. But I think it's a very different inquiry, and it takes us down a very uncertain path if you have courts say, in my intuition, this relates to health, notwithstanding what the General Assembly said. And I think there's this broader question, of course, about whether all traffic safety laws relate to health. And we think no. We think that the authorities that we've given answer that question in the negative. But we would urge the court to at least consider the financing exception and to rule on that basis. And if I might, I'd just like to explain why that's so important to the General Assembly. Every single every single budget over the past century, my understanding, it would be subject to constitutional challenges if this court said, that health-related allocations to a particular county or to a particular area are subject to constitutional challenge. But there isn't, as the Supreme Court said in Brown, this broad financing exception. My understanding is that in the current budget, there's $125 million that's going to go to a hospital, to build a hospital in Greenville. And I think there are, my friend on the other side has reasonable arguments that we very much welcome, that those kinds of allocations would not be subject to constitutional challenge. But it would be, we find it difficult to see how those would materialize if there isn't some ratification of the financing exception.
So if we agreed with you on that, the 3-judge panel made a determination that that could be interpreted as broadly as that the underlying statute as well did not relate to health, the underlying red light traffic camera statute, because they concluded that red light traffic cameras don't have any relation to health. If we agreed with you, we would decide this case on the financing exception or just even saying this is only tangentially or incidentally related to that finding by the 3-judge panel would have no precedential value. these even same plaintiffs could come back later and challenge the underlying law. I mean, that question would remain open. Do you agree with that?
Yes, we would agree with that. We think that, perhaps as a matter of broad-based judicial efficiency, it would make sense for a court to answer that question. We would think it would be dicta just based on the nature of the challenge. If you look at their complaint, this is on page 4 of the record, they just ask for the financing law to be, the 2016 session law to be struck down. They don't talk about the underlying law. And at least Ms. Vaitovas, through her counsel, has conceded that law, the underlying law, is constitutional. We don't think you need to reach that issue, but of course, as a matter of judicial efficiency, it might make sense. I think, if I might turn to a separate topic, so we think it would be helpful for the court to view this interpretive question by reference to all the other sources, legal sources, that include similar language. So there's nothing else in the Constitution, but there are many statutes, federal, state, that say things like governments can do certain things related to health. And often that they're authorizations of power. So, this is not hypothetical. Say there's a federal or state statute that says Greenville can use certain money that the General Assembly is allocating or the federal Congress is allocating for health-related projects. Plaintiff's position seems to be that they could take that money and use it to build red light cameras. I don't think that would make any sense. I think that they might, if they did so, they might be subject, to recoupment action.
I find that a very persuasive argument. I think that what we're struggling with is that's because that's, the statute that Congress enacts, we would examine it using the meaning of those words today, and we just seem to be struggling with, so long ago when, cars were somewhat novel, as you pointed out, maybe not as novel as we tend to think in hindsight, but, this idea that this is all relatively new. So what did the word health mean? And, so for example, there were no environmental laws at that time the way we think of today. So what we might call an environmental law today would have been a sanitation or abatement of nuisances, was what the framers would have described it then. So that's what we're struggling with. What did health mean then?
So I take the point, Your Honor, and it's a very good one. I would say that there are a lot of situations, environmental laws, workplace labor laws, where, it's actually kind of hard to engage in the inquiry of what the 1916 General Assembly or the fall of 1916 people of North Carolina, what do they think when they saw the word health? But here, it's actually a little bit easier because I think it's not as easy if it were something like criminal laws. So if the underlying prohibition were a criminal law, I think we would all say, well, they didn't say criminal in the list of topics, and that was one of the most common topics of legislation. So you would just infer that health doesn't mean an effect, a criminal law where the underlying prohibition. Right,
where you murder someone, which of course
exactly. That's much more direct way of saying it. So yeah, but here traffic. I did some research on this in preparation for today, and 1917 was a time when traffic laws were very common. There were a lot of cars on the roads. It was a subject of a lot of legislation, local, state, national, and we can submit more laws. There's many more laws in the teens and the 20s where there's all these local traffic safety laws. And so I think that the General Assembly would have said traffic safety or public safety or something like that if they intended to cover those topics. So, don't want to belabor the presentation. I guess I would like to just make a quick point about New Bern, because I think New Bern is the hardest case for our position. And I think what that case highlights is it's two things. One is that wasn't a supplemental financing law. I think that case would have turned out differently if all that local law did was say, the city of New Bern, we let you, enter into new contracts so you can engage in building inspections more efficiently. That's not what the law did. It transferred authority from a city to a county. And I think if there's one through line through all the court's cases, the Supreme Court's cases, this court's cases on local laws, it's when the General Assembly is involving itself in these kinds of local governance disputes, then judicial scrutiny is warranted. And the second point I'd make on New Bern is that, again, the General Assembly itself said building code inspections relate to health. And there's nothing in the record here other than statements by, they're mainly statements by the local officials, not by the General Assembly. But there's nothing like that here in enacted statutory text that says, we, the General Assembly, believe that traffic enforcement relates to health. So with that, I'll sit down unless there are any further questions.
All right, thank you, counsel.
Thank you.
Rebuttal?
I think the most interesting question here is what was the practical effect of this legislation? And the record doesn't leave us asking, what is the practical effect? To quote from Mark Holtzman's affidavit at page 344 of the record, he lists several practical effects of the program. He says a practical effect is to reduce crashes at intersections covered by the program. Every notice of violation that the City of Greenville sends out, and this is also in the record, says that this program has been designed to reduce red light running violations, collisions, and injuries without impacting city funds. I think that's the shortest synopsis of the effect of this program and the effect of this legislation that you'll find in the record. Sure, there's a financial effect, but there's also a health effect. To try to avoid that health effect, the defendants cite irrelevant authorities, and they talk about local traffic laws at the turn of the century that were enacted after this constitutional provision to try to argue what the constitutional provision meant at the time. I'd like to point out one thing about those local traffic laws, which is, and this relies on, I suppose, an assumption that I'm making, which is that motor vehicles weren't terribly common in 1916, probably weren't even terribly common in 1920. You may find motor vehicles in Wake County or Mecklenburg County, but you probably wouldn't find them in Scotland or Halifax County. So in those cases, it may make sense to have a local law, and in that case, it really wouldn't be a local law targeting a specific condition in a specific locality, where the entire state doesn't have paved roads that are acceptable for automobiles, and not everyone in the state has automobiles. If they're only driving in Wake County, then fine, make a traffic law that only affects Wake County. But that's just not the condition today, Your Honor. The condition today is that people drive all across North Carolina. They drive into and out of the state. And for the sake of our commerce, for the sake of our safety, for the sake of our citizens being on notice about what is and is not criminal, we have a uniform traffic code. We have Chapter 20 of the general statutes. And I'd like to talk about a few of the authorities about whether or not this relates to health and whether or not health financing or health enforcement relates to health. The defendants, the legislative defendants, cite a number of cases saying that financing doesn't relate to a particular subject. You have to look at the specific provision of Article 2, Section 24 in each of those cases, because Article 2, Section 24 doesn't use the same language for each provision. There's, for example, the first provision is the one that we're here about, relating to health, sanitation, and abatement of nuisances. The next is changing the names of cities, towns, and townships. So the cases that the defendants cite, by and large, deal with other provisions that don't have this same relating to language. Brown and In re resolutions deal with acts authorizing the laying out, opening, altering, maintaining, or discontinuing of highways, streets, or alleys. Fletcher versus Collins deals with local acts establishing or changing the lines of school districts. The only case that they actually cite that addresses this relating to standard is McIntyre, and McIntyre primarily addressed whether or not the challenge legislation was actually a local act. But McIntyre did hold that the act, which financed justices of the peace differently, related directly to the appointment of justices of the peace and was unconstitutional. And that's at 254 North Carolina Reporter, page 516. So if we take that decision, McIntyre, and we look at the other cases, we see a trend here. When you look at Lamb, for example, the argument that this is not something that municipalities have the authority to do just doesn't hold water if you read Lamb. Lamb was about whether or not a board of education could expend funds to ensure sanitary conditions in its schools. I'm assuming that a Board of Education does in fact have the authority to ensure that its schools are sanitary. But the General Assembly limited that board's authority, and the North Carolina Supreme Court held that limitation was unconstitutional because it related to health. Newbern 2 is the most important case for your honors. I think without Newbern 2, we may not be here in court today. Newbern 2 clearly establishes that safety does in fact relate to health under the right circumstances. There, the court held the enforcement of fire regulations protects lives from fire, explosion, and health hazards. We find the conclusion that inspections pursuant to the code affect health and sanitation inescapable. Where this is really a problem for my friends on the other side is they raise the presumption of constitutionality above, I think, its intended meaning. They make it a very high barrier that we have to jump over, that the court has to try to construe the Constitution and the statute in ways that uphold the statute. Well, if that were true, the court in Newbern should have said, okay, well, plumbing, yeah, that relates to health and sanitation, but we're going to separate out this provision that relates to just fires and explosions and hazards like that and say, well, that doesn't relate to health, because we can construe this statute in a way that saves some of its constitutionality. But the court in Newbern didn't do that. The court in Newbern specifically called out those fire safety hazards and said those fire safety hazards relate to health.
So one thing, if we're trying to harmonize, because I agree that the Newbern case is a very good case for your argument, but if we try to harmonize that with the argument that we heard from the Solicitor General, which is that, so murdering someone relates to their health because now they're dead, but you certainly can see from looking at the use of the word criminal and the idea of criminal codes that the framers would not have considered criminal laws to be health-related laws. So there must be some spectrum between Newbern and looking at fire codes and getting to things like criminal laws. And then the question is, where along that spectrum would a traffic safety law like this fall? And doesn't it seem to be closer to kind of a criminal law than it is to something like a fire code?
I think if we were looking at the underlying authorization for red light cameras, I may possibly agree with you, or if we were looking at a law that criminalized red light running. But we're a step away from that. We're not looking at the criminal law. We're looking at the law for enforcing the criminal law. And there's a difference between the underlying law and enforcement. That's what Newbern 2 recognized. When you change the enforcement mechanism, that has an effect on health. That's what City of Asheville recognized. When you change the enforcement mechanism, that has an effect on health. This is not a law saying running red lights is illegal. It's not that law saying murdering people is illegal. This would be like a law saying we're going to put cameras in all of your houses, and if someone shoots someone, we're going to record it on camera, and that will reduce the crime rate in our city, reduce murders, and save lives. So you should agree to have cameras. It's not the underlying criminal law, it's an enforcement law. And that's really what I want your honors to remember when you consider this case, that this is an enforcement law. And our cases have clearly held that enforcement law relates to health. I'd leave you with one last quote from Williams versus Blue Cross and Blue Shield. There, the court held that the defendant's argument that the purportedly pervasive nature of the enabling legislation renders it valid is unpersuasive, because validity is judged by what can be done under a statute, not by what has actually been done under the statute. Thank you, your honors.
All right, thank you, counsel. We'll adjourn.
All rise. This session of the North Carolina Court of Appeals is now adjourned.